we're on to desire to prefer.
That's exactly right. My Lord, we were just in the process of dealing with ground 2. As I indicated, this is on the footing we're wrong on ground 1. We're looking at the question of whether Mr. Enoch, assuming he did make the decision to repay the Kill RCF on behalf of Comet in November 2011, had the requisite desire to prefer. As I was explaining to my Lords and my Lady before the short adjournment, there's no direct evidence of the desire to prefer. The judge's approach was to draw an inference based on certain findings of fact, which she did make.
Yeah.
And as I'll show you in a minute, we don't challenge the findings of fact, but we do say they don't provide any basis at all for the inference that she sought to draw. Now, starting then with the judgment, the learned judge dealt with this in paragraph 220 onwards, which is page 157 behind divider 6 of the core bundle. And I'm going to begin by identifying the findings of fact which she made. 220, she begins by setting out what is a correct statement of the law in our submission. And then in 221, she makes a finding of fact that Mr. Enoch and others at KISA knew that there was a risk of an insolvency process of Comet. Now, importantly, and then she develops that at 223, as you can see. What's important about that factual finding is she's talking about a risk of an insolvency process whilst it remains under the ownership of Op Capita, or whilst it was under the ownership of Op Capita, because she accepts at the first sentence of 225 that whilst it being Comet remained part of KISA, there was no contemplation of an insolvent liquidation. So when she says they undoubtedly knew there was a risk of an insolvency process, she's talking about the position following the transfer to Op Capita. As I say, she accepts at 225 that whilst it remained part of KISA, insolvency wasn't going to be a prospect because KISA would simply continue supporting it. So the first finding is that one you see at 221 and 223, but subject to the explanation and qualification at 225. 226 I'll come back to because that's where she deals with the submission, which I'm now making to your lordships and your ladyship. The other factual findings she makes are dealt with in 227 to 229, but are summarised in the final two sentences of 230. Because as she says at the end of 230, as Millett J explained in MC Bacon, the existence of a desire to prefer can be inferred from the circumstances. And then the two other findings which she has made is firstly that the disposal was deliberately structured to have the effect that the Kill RCF was repaid. And secondly, that KISA positively desired to achieve that result, namely the repayment of the Kill RCF. Now, as we say in the skeleton argument, there's therefore three primary findings of fact which she did make. If you go to our skeleton at paragraph 38, page 41, behind divider 2, we've summarised those three findings here in a convenient place. So as we say in the second sentence of paragraph 38, her finding was based on an inference, and that was based on three primary findings of fact, which I've shown you, that the transaction was deliberately structured to involve a repayment and not a capitalisation of the Kill RCF, that KISA desired a repayment and not a capitalisation, and that Mr. Enoch contemplated the possibility of an insolvent liquidation of Comet under the control of Op Capita. And then, in effect, what the judge has done is inferred from that Mr. Enoch must have had a desire to prefer Kill when making the decision on behalf of Comet to repay the RCF. Now, as we say in 39, we don't challenge the primary findings of fact which the judge made, those 3 primary findings. But we do say they don't provide any proper basis to make the inference which the judge did. And there's 3 points which we make in support of that. The first is what may be an obvious point, but the mere fact that the transaction involved repayment of the KIL RCF and that KISA desired repayment of its debt is obviously insufficient. I showed the court that from MC Bacon. It's not enough to desire the repayment of the debt. You have to desire to put the creditor in a better position than it would have been in the insolvent liquidation. So to the extent the judge is basing this on a desire to obtain repayment of the debt and the transaction being structured to obtain repayment of the debt, that isn't by itself enough.
I mean, that's clear from the language of section 39 subsection 5.
Exactly.
Yeah.
Now, secondly, the fact that the KIL RCF was repaid as part of the transaction was entirely explicable by the fact that in a corporate M&A transaction such as this, it would be usual and conventional for the intercompany lending between the retained part of the group and the part of the group being sold to be settled one way or another. And the reason for that is that neither side will want the selling group to remain as a lender to the sold part of the group or vice versa. And the judge accepted elsewhere in the judgment and found that KISA's desire was to achieve what was called a clean break. And if I can give your lordship and my lady the references to that. In the judgment, you find it first in paragraph 66, page 125. So it's the third sentence of paragraph 66 on 125. The overriding objective was to achieve a clean break, which capped KISA's exposure to Comet. And then 207 on page 154. 207, KISA's overriding objective was to achieve a clean break from Comet with its downside risk capped. And then 244 on page 162, it's the anti-penultimate sentence. KISA was driven entirely by the desire for a clean break whilst meeting its objectives, leaving Comet a capital structure that could allow it to continue as a going concern. And that's what the judge found in my submission for what it's worth. That makes perfect commercial sense because it's what you'd expect in this type of transaction where a seller is getting rid of a group of companies to a buyer. The seller isn't going to wish to remain, in effect, as the treasury company to the entities that have been sold. Now,
there's a bit of a move between the first 2 paragraphs you showed us in 244 from overriding objective to
given entirely. Yes. Yes. I mean, I don't think, that distinction might be helpful to us in the sense 244, she's putting it more firmly, but ultimately what this point comes down to is this. If one accepts that the cancellation, the zeroing of the intercompany balances is simply a normal part of mergers and acquisition transaction under which a company is being sold, then there isn't any basis for inferring that the repayment of the intercompany lending is influenced by a desire to prefer.
I don't think the judge did accept that, did she? She says at 209
yes.
that there are other ways of doing it.
Yes.
And at 215 this was far from a routine sale.
Well, 209 we rely on because what we say would happen in an intercompany transaction such as this is you would remove the intercompany balances, and there's a number of different ways of doing it, as the judge rightly points out in 209. You can either do it by way of repayment, or alternatively, you could do it by way of assignment, or waiver, or capitalisation. So there's a number of different means.
But assignment, of course, would leave the debt untouched. It would still be a debt.
It would.
It would be owed to a different
It would.
company, but it would still be a debt.
Yes.
And that company would be entitled to rank pari passu with other creditors in the event of an insolvent liquidation.
Yes, but not the creditor. The creditor in question, who's the beneficiary of the assignment, would have been paid in full. So, I mean, our point on this is simply to say, as part of this sort of transaction, the ultimate objective was to achieve a clean break between the selling entity and the buying entity, and that in those circumstances, there isn't any basis for inferring that the repayment of the loan was driven by a desire to prefer kill, as simply being driven by a desire to achieve the clean break between the selling entity and the buying entity. In other words, if you're looking at an inference, it's at least equally plausible that the relevant desire was simply to achieve a clean break as part of the transaction under which the companies were being sold. So,
which is what she's found in relation to Keyser in paragraph 244.
Exactly, yes. So, I mean, if one's drawing an inference, it seems to us that you can't draw the inference from simply the fact that the debt was repaid or that it was structured to repay the debt. And equally, we would submit you can't draw the inference from the fact that the transaction was entered into and resulted in the debt being repaid, because it's equally consistent that that was simply driven by the fact that as part of this sort of transaction, one would need to remove the lending in place between the entities which were not being sold and the entities which were being sold. So, in our submission, those 2 points undermine the inference which the judge drew. But there is, however, a further point, which is the third point, and that is, on the facts of this case, there was never, in fact, a scenario in which Kill would have remained a creditor of Comet and where Comet was at risk of going into insolvent liquidation. Now, the evidence clearly showed, and the judge accepted, that whilst Comet remained under the ownership of Keyser, there was no real prospect of it being placed into insolvent liquidation. Now, I showed you paragraph 225 of the judgment. There's also paragraph 79, which, if you go to page 127, paragraph 79, referring to the evidence of Mr. Platt, who was the chief financial officer, his evidence was straightforward and helpful. He was of particular assistance in explaining the position in relation to credit insurance, the fact that an insolvency process was not a viable option under Keyser's ownership. So whilst Comet remained part of Keyser, there was never a scenario in which Kill would have ended up being a creditor of Comet in an insolvent liquidation. Now, the other...
So just to tease that one out, so you say that even accepting that Mr. Enoch had in mind the possibility of an insolvency process or insolvent liquidation, that would only have been once Comet had left the Keyser Group, and in that scenario, Kill would not be a creditor, therefore could not be preferred.
That's exactly the point, exactly. So your lordship's leapt ahead to the conclusion, but that's exactly the point. So whilst Comet remained under the ownership of Keyser, there was no possibility of going into insolvent liquidation. Equally, whilst Comet was under the ownership of Capita, there was no scenario in which Kill would be a creditor of Comet. And given those two points, which are unassailable findings on the judge's judgment, there's no basis for saying that this payment was driven by a desire to prefer Kill in the event of an insolvent liquidation of Comet, because there was never a scenario in which Kill would have been a creditor of Comet whilst it was in insolvent liquidation. That was just not a possible scenario.
For a moment. So suppose you've got this situation, this sort of situation, and those in charge of the creditor company say to themselves, look, it's entirely unacceptable to allow this company to fail while we own it.
Yes.
But we certainly don't want to be landed with the burden of keeping say we'd like to dispose of it in circumstances where we think it's really very likely that it will fail in the hands of the successor.
Yes.
And we don't want to be left with our debt outstanding. We have various options we could have taken, but we've chosen this one because it means we get paid, and we know the company is likely to fail, but when it fails, we're not going to be left as an unsecured creditor. We're going to, can it really be that that isn't within the scope of the preference provisions?
Well, it's capable of being within the scope of the preference provisions, but it depends on the state of mind of the company which repays the loan. So, I mean, in that scenario, if the company which repays the loan has the requisite desire to prefer, absolutely, that's going to be a preference. The feature of this case, which is so striking, is that it's conceded that the people who make the payment weren't motivated by desire to prefer, and that no doubt reflects the fact that actually they probably thought this was in the best interest of the company at the time, because they looked at the fact that Kisa was putting in money, Kisa was taking out the pension scheme, they thought they had a business plan, they thought they had new funding. It actually didn't do badly post the transaction, so they came to the view it was a bona fide decision for them to make. But I think in answer to your question, I don't submit it can never come within, but all the sort of interesting points we're debating in this case all stem from the fact that the liquidator accepts that the post-sale board didn't have the requisite desire to prefer.
Yes, I mean, we're assuming at this stage you've lost on point one.
Yes. Yes.
So the key decision is that taken in November.
Yes.
And suppose, which are not our facts, that Mr. Enoch had been the key decision maker in Kisa and the key decision maker in Comet at that point.
Yes.
And wearing his group hat had thought, look, we've got to get rid of this company. So be it, it's going to fail in the hands of the successor owner, but that doesn't matter so long as we're paid.
Yes.
So acting qua Comet as well as qua parent company, he has the intention that the parent company should be repaid, even though he knows that the company is likely to fail. So is that within the scope of the preference provision?
Well, no, it wouldn't be, because, I mean, in that scenario, he could simply have dealt with the debt by way of an assignment or a waiver or a capitalisation. I mean, he could. I mean, that is the counterfactual to repaying the debt. I mean,
So is the answer that you can't infer the nefarious purpose because he could have achieved the same result without the nefarious purpose?
Yes, because the counterfactual, you have to ask yourself, well, what would be the counterfactual to not making the repayment? Now, if the counterfactual to not making the repayment is that Kill would have ended up in an insolvent liquidation, and that's going to be a preference, potentially. If the actual counterfactual is that actually the debt would just have been discharged by another means, whether it be waiver, capitalisation, or assignment, then it's not going to be a preference, because it doesn't put the creditor in a better position than it would otherwise have been in an insolvent liquidation.
So if another alternative would have been just as good, you can't infer the intention to prefer.
Yes, because it's all about inference.
No, quite. Yes. But does that not invite you to consider, well, why did they do it this way and not take one of the other options? As to which I'm not sure we know the answer.
Well, I mean, you could consider what the other options are, but I mean, in my submission, ultimately one has to fall back on the fact that the judge's reasoning is based on an inference here, which she has drawn from those three primary facts I've mentioned. But if, as we submit, was the position that actually there was never going to be, on the facts of this case, a scenario in which Kill was going to be the creditor of Comet in insolvent liquidation, because on the facts of this case, if the debt hadn't been repaid, it would have been waived or capitalised or assigned, then we respectfully submit it's impossible to infer that the reason it was repaid was because of a desire to put Kill in a better position than it would otherwise have been in on a liquidation of Comet. it was never going to be a creditor of Comet whilst it was in liquidation. That was just not
to distinguish. I mean, the statute distinguishes between the decision to give the preference and the actual giving of the preference, and those may happen at the same time, but they may happen at separate times. And what you've got to deal with is, on the assumption that the judge was right about the inference she drew about the decision,
yes,
whether or not her reasoning stacks up at the later stage when the preference is conferred, I think.
No, it's when the decision was made. So except for the purposes of this argument, we're accepting that the decision was made by Mr. Enoch in November 2021, and he did that on behalf of Comet. So one's looking at what he was influenced by at that time in making that decision. And as
so
I said,
if the judge were to have concluded, Mr. Enoch recognised the possibility that once Comet was sold, there was a real risk of insolvent liquidation, and he thought to himself, we better get our money out before that happens.
yes,
Could that not be a preference?
a real risk of insolvent liquidation whilst it remained under Keith's ownership.
No. He's negotiating the terms of a transaction, the whole purpose of which is to take Comet out of Keith's ownership.
Yes, exactly.
And he recognises that in that scenario there is a risk of insolvent liquidation.
Yes.
Therefore, he says,
yes.
we, Keyser, had better get our money out.
Yes.
Why is that not capable of being a preference?
Because if the debt hadn't been repaid, it would simply have been capitalised or assigned.
Well, it could have been.
It
Who
could.
says it would have been?
Well, this is perhaps the critical point, because one needs to identify what the hypothetical counterfactual is to the repayment of the debt. And our point is that on the judge's findings, because she recognised and accepted that this was driven by the need for a clean break, that this debt was always going to be dealt with by one way or another. There wasn't a world in which Kill would have remained as a creditor of Comet post-transaction. It was going to be dealt with because there was always going to be a clean break. That was either the objective or the entire objective of the transaction. So our point is simply that if it hadn't been dealt with by way of repayment, the hypothetical counterfactual would just have been dealt with by assignment or waiver or capitalisation. But it wouldn't have led to a situation where Kill... And if that's right, then in our submission it's impossible to say that Mr. Enoch was driven by the requisite desire in 239 in making the payment, because he would have, if you'd asked him, well, he said, well, we'd have just dealt with it by assignment, we'd have waived it, we'd have capitalised it.
I think I follow this submission, but I'd just like to be clear. When you say relevant counterfactual,
Yes.
do you mean any more than that you can't infer from the fact that he took this route that he had a nefarious purpose, because he could just as well have done other things that would have had the same result?
I mean, that's effectively, that's putting it with much more clarity than I was putting it, but that's essentially the point. And when you say nefarious purpose, i.e. non-preferential, so, and I think in our submission one has to take a step back, and you have to put yourself in Mr. Enoch's mind, hypothetically in November, and ask yourself, well, was he, in deciding to repay the Kill RCF, driven by that desire to put Kill in a better position in the event of an insolvent liquidation of Comet? And we say if you'd asked him, he would have said, well, no, that's absurd, because we were never going to be a creditor of Comet in an insolvent liquidation, and if the debt hadn't been repaid, we'd have just obtained its discharge by waiver or capitalisation or assignment.
Yeah.
So I think, that's the point, and ultimately we say findings of fact don't support the inference.
I'm sorry to waste time, but just so I understand. Say that they thought to themselves, no, well, repayment of the debt isn't a good option. How would one of those alternatives have worked out in practice? Would it have been the same from Capita's point of view, or might they have objected?
The same, well, it would have obviously affected all those mechanics we were looking at, because those were structured on the basis that there would be a repayment of debt. But in our submission, if the transaction was to have taken place at all, it would have involved a clean break, so it would have been achieved one way or the other. I mean, I think you've got two worlds here. I mean, either you've got a world where the transaction doesn't go ahead, Comet remains part of KISA, in which case no insolvent liquidation. You've got a world where the transaction does go ahead in some form, and in that world, Kill isn't going to be a creditor of Comet.
I mean, there was more than one potential way in which KISA could put in 38 million or
Yes.
whatever, and be left with nothing owed to it.
Exactly.
Yeah.
And that's why, I mean, we rely on really, I mean, the judge accepted this at 209 of the judgment. I mean, and she's right. There's a number of ways in which one could have achieved the same result, which include, well, which are really assignment, capitalisation or waiver.
Yeah.
Yeah. And indeed, I mean, you get this point actually because the judge makes it herself very clearly at the end of 228 on
228.
At the end of 228 on 159. And indeed, this is really our point. Any of the much more obvious alternatives of assignment, waiver, or capitalisation would not have had the effect of conferring a preference, but would still have allowed a clean break. That's exactly our point. If it hadn't been dealt with by repayment, it would have been dealt with by one of those alternatives, which, as the judge said, would not have conferred a preference, or, to use your lordship terminology, no nefarious purpose. And so you get 209 and 228 are the key findings on the alternatives. Now, the judge looked at this point and addressed our submission in paragraphs 225 to 227, 158. So at 225, she records essentially the same submission which I've been making to your lordships.
Yeah.
And your ladyship. And then the judge said at 226, I don't consider this as fatal. If the submission was correct, then that would materially undermine the effectiveness of 239. It would really amount to saying that it cannot apply in any situation where a debtor is prepared to do whatever it takes to immunise a particular creditor from the insolvency process by paying them off before there's a real process. For there's a real risk of any such process commencing. It makes no difference that paying off the debt may be part of a broader transaction in which the shares are also transferred. Now, in our submission, this doesn't answer our point with respect to the judge. Our point is that the alternative to repayment of the debt was that the debt would have been extinguished by other means, such that there was never a prospect of Kill being a creditor of Comet in an insolvency proceeding of Comet. And the alternative to repayment of the debt was not that Kill would have been left claiming as an unsecured creditor in a Comet insolvency, but rather it would have been discharged by way of assignment, waiver or capitalisation. And likewise, we respectfully suggest 227 doesn't deal with the point. So far as the first sentence is concerned, that's looking at the position as if there had been no transaction. And it's undoubtedly true that Kill would have remained a creditor of Comet in those circumstances. But as the judge found, there was no prospect of Comet going into an insolvency proceeding whilst it remained under KISA's ownership. So the first transaction doesn't help. The second sentence may well be right, in the sense that the disposal allowed KISA to extract itself with exposure firmly capped, possibly below the cost it might have incurred in continuing to turn Comet around or close it down. But that isn't the test under 239. And third sentence, I mean, it's not entirely clear, but again, the judge appears to be looking at the position as if there'd been no disposal at all. And again, it's true in this situation, KISA may have been required to put in more funding to keep Comet afloat. But that, again, doesn't make repayment of the kill RCF a preference. We respectfully submit those paragraphs 226 to 227 don't really answer the actual point we were making in 225. So that's ground 2, which is attacking the judge's inference of the desire to prefer on the part of Mr. Enoch. I'm going to turn finally then to the third ground of appeal, which is the question of insolvency.
Well, there's a gap, isn't there? Because having found that Keyser had a desire to prefer,
yes,
that desire then has to be imputed to Comet.
Yes. Well, that's right. Yes. So she has to. I mean, in effect, she has to say it's Mr. Enoch who has. The way the judge approached that is to say it's Mr. Enoch who had the desire to prefer, and then you get into exactly the same points which I was making in relation to ground 1 about whether Mr. Enoch was wearing his Comet or his Keyser hat.
Yeah.
So your logic is absolutely right. Those points apply equally in relation to ground 2 as well.
And in cross-examination terms, none of this obviously will have been put, at least in an adversarial way or in a relevant way, to Mr. Dark or the new directors.
Correct.
I can't remember who else you had. Was it?
We had Mr. Clare and Mr. Dark from the post-sale board, and we had Mr. Enoch. And then we had Mr. Goldring, who was the lawyer from Berlin.
So this could only have been explored with Mr. Enoch?
I think so. I mean, you could have, you could have explored it with Mr. Dark relevantly, because he was
a director throughout.
Exactly, yeah, because he was a director at the time.
But if the hypothesis is that the intention to prefer is to be found in Keyser and Mr. Enoch,
yes,
the only person who could speak to that would have been Mr. Enoch.
yes, I think that must be right, because effectively they're saying it was in Mr. Enoch's head, and it wasn't put to Mr. Enoch. It was not put to him. So that's the second ground, and then the third ground is obviously somewhat different, because this is on the topic of insolvency. And as I mentioned, Your Lordship, Your Ladyship, at the start, the liquidator put his case on various different bases, as he was perfectly entitled to do. But the formulation the judge accepted was balance sheet insolvency immediately prior to the transaction.
It's not suggested, is it, that there is any material difference between Comet's solvency or lack of it in November 2011 and its solvency or lack of it in February 2012, because the judge's findings relate to the latter date.
They do. Obviously all the evidence was directed at the position as at the end of January, because going into the trial, one of us focused on the 3rd of February date. It was the judge's finding in her judgment that the decision was taken earlier in November. None of the evidence was, I think, directed at that point. We're not taking a point on appeal, because we're not in a position to do so. If one was going to...
We can treat her findings as being as referable to November 2011 as to February 2012.
I think that's right, because what I'm not doing on appeal is running a point to say that Comet wasn't insolvent at November, even if it was at January. So I think that's fair, my lord. So what we're looking at, oh yes, my friend Mr. Phillips makes a good point anyway, which is that so far as insolvency is concerned, you look at the position at the time the preference was given rather than when the decision was made.
Well, the insolvency goes to what is a relevant time, doesn't it?
Yes, exactly.
And the relevant time is the time of decision, says MC Bacon, I thought. Perhaps not.
Time of the decision is, you've got to have the desire to prefer has to be at the time of the decision to give the preference.
So you have to be insolvent at the time the preference is given. Yeah.
So if the decision to give the preference and the giving of the preference are not one at the same time, then there is a potential difference.
Exactly, yes.
Yeah.
I mean, it's perhaps a little curiosity of the legislation, but under Section 240, the insolvency is looked at the time when the preference is given. So it's really Section 240, subsection 2, actually, where a company gives a preference at a time mentioned in subsection 1, that time is not a relevant time unless it is at that time unable to pay its debts or becomes unable to pay its debts as a consequence of the preference.
Sorry, which section are you looking at?
Section
240,
240,
subsection
subsection 2. So it's
Right.
so I think that means we look at the position technically on the 3rd of February, but the way that was approached was to look at the position at the preceding month end, which was the 31st of January. Now, the judge accepted the case on balance sheet insolvency immediately prior to the transaction, and we say that she was wrong. So far as the law is concerned, it's, in our submission, conveniently set out in the judgment of this court in a case called Bucci against Carmen, which is in the authorities bundle, divider 21. Paragraph 27 in the judgment of my Lord Justice Lewison summarises the relevant principles derived from, amongst other places, euro sale. And just to emphasise relevantly for our purposes, in Roman numeral 3, the balance sheet test, especially when applied to contingent and prospective liabilities, is not a mechanical test. The express reference to assets and liabilities is a practical recognition that once the court has to move beyond the reasonably near future, any attempt to apply cash flow test will become completely speculative, and a comparison of present assets with present and future liabilities, discounted for contingencies and deferment, becomes the only sensible test. And then Roman numeral 4 in our submission is particularly important, but it's very far from an exact test. Whether the balance sheet test is satisfied depends on the available evidence as the circumstances of a particular case. And then this, it requires the court to make a judgment whether it's been established that looking at the company's assets, making proper allowance for its prospective and contingent liabilities, it cannot reasonably be expected to meet those liabilities. In that sense, that's the essential question the court is asking itself. Now, one gets a lot of evidence from accounting experts with ever more complicated balance sheets prepared with differing financial standards and so on. But it's not ultimately an accounting exercise. What the court has to ask itself is a practical, real-world question of whether the company can reasonably be expected to meet its debts. And you get that from Roman numeral 4. And also similarly, what my Lord said in paragraph 29. And this is the third sentence of paragraph 29. Thus, I agree with Mr. Justice Warren at 34 that the two tests, namely cash flow and balance sheet, feature as part of a single exercise, namely to determine whether a company is unable to pay its debts. That is the question which one has to answer. And for your Lordship's note, you get essentially the same in paragraph 42 of Euro Sale, where Lord Walker agreed with Lord Justice Toulson in the Court of Appeal. Now, ultimately then, the question one is asking is whether in the real world can this company reasonably be expected to repay its debts. Now that, in our submission...
Sorry to interrupt, Mr. Smith, but is that right? Because the definition of inability to pay debts is in section 123.
Yes.
And just cutting to the chase, there are two relevant tests. There's 23(1)(e),
Yes.
If it's proved for satisfaction of the court the company is unable to pay its debts as therefore due, then subsection 2 is a deeming provision. The company is also deemed unable to pay its debt if it's proved to satisfaction of the court that the value of the company's assets is less than the amount of its liabilities,
Yes.
taking into account its contingent and prospective liabilities. So there are potentially two separate questions, aren't there?
Well, there are the two tests, so that's absolutely right. So 1231E is what's referred to as cash flow insolvency. So is the company in fact able to pay its debts as they fall due out of available cash? And then 1232 is what we refer to as balance sheet insolvency, which is looking at the assets and liabilities, but discounting future and contingent liabilities in the appropriate way.
But I mean, they're two different exercises and might arrive at different results.
Well,
mightn't they?
I mean, they are two different exercises, but ultimately the question they're both seeking to answer is the same, which is whether this company is reasonably expected to pay its debts or not. And the cash flow test tends to look at the position in the near future. The point that was made in Eurosale is you can apply the cash flow test to a point in time, but then it becomes completely speculative, and then you would move to the balance sheet test. I mean, it might be helpful. Let me just look at what. Yes, I mean we'd also, if you go to Eurosale at paragraph 42, in the judgment of Lord Walker, which is tab 18 of the authorities bundle. Lord Walker quotes Lord Justice Toulson in the Court of Appeal in Eurosale, which says he agrees. And what Lord Justice Toulson said, essentially, section 123.2 requires the court to make a judgment whether it's been established that looking at the company's assets, making proper allowance for its contingent liabilities, it cannot reasonably be expected to meet those liabilities. If so, it would be deemed insolvent, although it is currently able to pay its debts they fall due. The more distant the liabilities, the harder this would be to establish. So the only point I'm really making is that the balance sheet test, it's not a mechanistic accounting exercise. You're actually asking yourself a real-world question, which is whether the company can reasonably be expected to meet its liabilities or not. That's the question you're seeking to answer. And in my submission, that's what Eurosale is saying. That's what the Court of Appeal was saying in Bucci and Carmen. Now,
that's expressly directed to the language of section 123.
That's
subsection
correct.
2.
But that's
rather than 1E.
Yeah, exactly. But the judge didn't find that the company was cash flow insolvent. No. She accepted the company was cash flow solvent in this case. So we're only concerned with 1232. And the only point I'm trying to get from that is just to say it's not a question of just taking a balance sheet prepared in accordance with accounting standards. You actually have to ask yourself and make a judgment: is this company reasonably going to be able to take its liabilities or not? And in our submission, what that requires is to focus on the nature of the liabilities in the balance sheet and ask yourself whether those liabilities represent something which the company is likely to have to pay. If so, in what amount and when? And then ask if it's reasonable to think that the company will be able to pay it. That's essentially, in our submission, the exercise one is engaged upon. Now, ultimately, this comes down to quite a simple point in our submission on the KIL RCF, but let me just show you, first of all, the balance sheet which is at issue, which you will have in the supplemental bundle, first supplemental bundle behind divider 31.
Tab 31?
Tab 31, yes. So this is the actual document that was produced at the time. You can see from the left-hand corner, top left-hand corner, it's headed Comet Balance Sheet IFRS as of the 31st of December period 9. The column we are concerned with is the first shaded column, which is headed Comet only. Now, it's not ordered in a particularly helpful way, in that it doesn't divide it easily into assets, liabilities, and then giving you a net position. But I'll just take you through the constituent items, and then the only one that really matters for our purposes is the KIL RCF. But just looking at the items, you have, first of all, fixed assets of £94.6 million. Then underneath that, you have current assets of £249.6 million. Then current liabilities of £198.7 million. Now, just pausing there, there's a clear surplus of current assets over current liabilities of about £50 million. So, not surprising that the cash flow insolvency case didn't prevail. Now, what you then get is creditors due after 1 year of £85.2 million. There's then 2 tax assets, firstly one of £4.2 million, secondly one of £44.9 million. And then if you ignore the figures for share capital, share premium, and the profit and loss account, there's then a figure for net debt of £116.1 million. Now, that results in net liabilities of £6.7 million. And as I say, this is looking at the position pre-transaction, whilst Comet remained under the ownership of KISA.
So, sorry, net liabilities of
6.7 million.
So we don't see that figure.
You don't. So you have to derive from those figures which I've given you, and that's not controversial, because that figure's taken from my learned friend's expert's report. Now, just to get one issue out of the way, that 6.7 million is calculated on the basis that there is in the balance sheet a deferred tax asset of 44.9 million. And our position in closing was we accepted that under 1232 you would not include that, because that was a contingent asset. So that the judge proceeded on that basis. We're not obviously appealing that, having made that concession. So the 44.9 million would fall out of account. Now, rather, our position before the judge, and which we renew on this appeal, was by the same token, it was not appropriate to simply include the future and contingent liabilities of the company at full face value. And the key liability for these purposes is the liability under the KIL RCF. Now, just to explain where that features in the balance sheet, I showed you the net debt position of 116.1 million. If you look slightly further down, there is a group of entries that result in a balance of 116.1 million, and those explain how the net debt is calculated. And within that, there is the largest item labelled current account Comet of 128.5 million, and that's the KIL RCF. So the key item within the net debt was the KIL RCF, and indeed you can see immediately it's a highly material item on the balance sheet of 128.5 million in the context of a net liability position which was either 6.7 million or 6.7 million plus 44.9 if you take away the deferred tax asset. So the treatment of the KIL RCF is obviously absolutely critical.
But it is a real liability.
It's a real obligation. It only becomes a liability that has to be paid if KIL makes a demand.
Yeah. Whereas the tax credit was on the judge's findings was purely theoretical. It would never actually materialise.
Yes,
so they're different kinds of. They're not the same same thing on each side.
Yes,
of the equation.
I'm not saying that they are the same thing, and I mean, I accept that the tax asset depends on earning future profits. The point about the kill RCF is it depends on demand being made. Now, the point about the kill RCF is a different one, because you have to form a view on the likelihood of Comet, whilst it remains under the ownership of KISA, having to pay that liability. And let me just put this to test the proposition. I mean, if Kill had written a letter to Comet saying we will never demand on the Kill RCF, then in my submission you obviously wouldn't include that as a liability at full face value if you're assessing insolvency. So you have to form a view on the likelihood of the liability actually arising, and then that being something that Comet isn't able to pay. So that's our basic point. And what one doesn't do is just mechanistically include it at full face value without asking yourself that question. Now, and we say, on the facts of this case, the judge was simply wrong to include that at full face value in light of the circumstances of the case. Now, just showing your lordships and my lordships the documents, we have the Kill RCF behind tab 9, page 143. It's dated the 6th of July 2003. It's obviously rolled over from time to time. The key clause is on page 144, repayment and prepayment. Each advance shall be repayable together with all interest accrued thereon and other amounts owing in connection with such an advance upon our demand at any time or as otherwise agreed. So, fairly conventional. It's an intra-group demand facility, but repayment depends on Kill making demand on Comet for the repayment. Now, the other document on this is the letter of comfort, which you find at tab 12, page 175. And this was dated 26 July 2011, letter of financial support addressed from KISA Electricals PLC, which is the ultimate parent company, to Comet, obviously prepared in connection with Comet's financial accounts. We're pleased to confirm that KISA Electricals PLC will provide financial support to Comet in order that Comet meets its commitments to their full due for so long as it remains a part of the KISA group. So they commit to support it for so long as it remains part of KISA. KISA Group is currently evaluating some strategic structure options, which include the possible sale of Comet. Should Comet be sold, it's the current intention of KISA that Comet be sold as a going concern. Therefore, at this point in time, KISA expects Comet to remain going concern for a period of not less than 12 months from the date of the letter. We also confirm that whilst Comet is part of the group, we will not demand repayment of any amount owed by Comet to any other companies within the KISA Group for the next 12 months. So that's given by KISA to Comet. And then...
So it is contemplated that even if Comet is part of the group, there might be a demand after 12 months.
Well, I'm not sure one can say that, because the first paragraph isn't limited in time. I mean, the first paragraph simply says that financial support will be provided for so long as it remains part of the KISA group. The third paragraph is looking at the position for the next 12 months, but that is obviously because that's the period of time one requires to come to the going concern view on the accounts. In my submission, you can't imply from that it's saying that post 12 months it will make a demand.
I mean, supposing that Comet's financial circumstances had turned round entirely,
yes,
made a very large profit.
Yes.
The third paragraph would still bite, but the first paragraph would fall away because Comet could meet its commitments as they fell due regardless.
Yes, but exactly. But it wouldn't be insolvent then. So, I mean, what matters in our submission. I mean, one understands the third paragraph is put in there for the going concern view on the accounts. The first paragraph, they're committing to support Comet so long as it remains part of the KISA group, so that it can meet its commitments. So in other words, to maintain its solvency whilst it remains part of the KISA group. Now, that in our submission is absolutely consistent with the judge's findings that she made in the judgment about there being no realistic prospect of Comet being placed into an insolvency proceeding whilst it was part of KISA. And if I can just show you the references to that, we've looked at some of these already. It's back in tab 6 of the core bundle. So first of all, the final sentence of paragraph 71 on page 126. Final sentence of paragraph 71, there's no consideration of whether KISA would in fact allow that, namely the administration of Comet, to occur under its ownership, which in fact, and unsurprisingly as a listed group with other retail business operations, it would be highly unlikely to do. And then 79, which we looked at on page 127, referring to the evidence of Mr. Platt. In the first sentence, he was a particular assistance in explaining the position in relation to credit insurance, the fact that an insolvency process is not a viable option under KISA's ownership. And then 225, which we also looked at earlier, on page 158, I accept that no one at KISA seriously contemplated an insolvent liquidation.
Sorry, which paragraph?
So 225 on page 158, which we did look at earlier. So it's the first sentence. I accept that no one at KISA seriously contemplated an insolvent liquidation of Comet whilst it remained part of the KISA group. And then 289 on 171. And this is the penultimate sentence, and this is perhaps the clearest, which does also reflect the letter of comfort. And in any event, it's clear from the evidence that KISA would not have permitted Comet to default on its debts under its ownership. Now, in our submission, in these circumstances, it was wrong for the judge to take into account the killed debt simply at its full face value for the purposes of assessing balance sheet insolvency. She was looking at the position pre-transaction whilst Comet remained part of KISA. And in those circumstances, there was no basis at all to think that the debt would be demanded whilst Comet remained part of KISA. Certainly, if the consequence of that was to render Comet insolvent. This was an intercompany debt owed by one group company to another. It had been the subject of the letter of comfort, including the first paragraph. And moreover, the judge's own finding was that it was clear from the evidence that KISA would not have permitted Comet to default on its debts whilst under KISA's ownership. And that finding was obviously correct in light of the evidence from the documents and from the witnesses. And in those circumstances, it simply, in our submission, can't be right to say that this company was balance sheet insolvent on the basis of a liability which would in practice never have been demanded upon if the consequence of that was to render Comet insolvent. It just doesn't make any sense. And what the judge in our submission has done is fallen into the error of looking at this question in a very mechanistic accounting exercise type way based on the balance sheet, rather than asking herself, what does this liability actually represent? Is it actually likely to be demanded upon? What are the prospects of it actually being demanded upon? And if it is the company going to be able to repay it?
But wait a minute. By the time we get to the date when the preference is given,
Yes.
No longer part of the
it's
group.
going to be demanded. We know that from the SPA, the completion of it.
Yes, and but
certainty is, I mean, assuming that the Comet approves the whole deal,
yes,
it's bound to be demanded.
but that's yes, but that is in that scenario is demanded upon, and it's repaid. It's discharged.
Well, yes, it's replaced by a different debt to somebody
Yes,
else.
and importantly, my lord, the judge didn't find that Comet was insolvent post-transaction. I mean, she accepted that Comet was solvent post-transaction. So absolutely, the demand will be made as part of the transaction, but it's going to be repaid, and there is then a solvent entity.
Your point is that it should have been ignored because the demand wasn't going to be repaid.
Well,
whereas in fact it was.
Well, whilst
It may have
Comet...
been a different answer, but I find it difficult to see that pretending that the demand had not been made, when we know perfectly well it was just about to be made, is the answer.
Well, you're looking at the position pre-transaction here, and so long as Comet remained part of KISA, and if this transaction didn't take place, then it was not going to be demanded on, it wasn't going to be repaid. So as far as the transaction is concerned, it was demanded upon, but Comet was in a position to repay it because it was put in a position to repay it. Now, I mean, it seems to us, with respect to the judge, one can't take from that Comet was insolvent, because you either look at it on the basis that it continued under KISA's ownership, in which case, in reality, this was never going to be demanded upon, or you look at the position on the basis of the transaction that was about to occur, where it was demanded upon, but Comet was put in a position where it was able to repay it, and where it came out of the transaction as a solvent entity, as the judge accepted.
But the question, sorry, I'm probably being slow. For the purposes of section 240, subsection 2,
Yes.
the point at which you have to ask whether the company is insolvent, in short, is the point at which it gives the preference. So surely the preference is given on completion.
Well, that's right. We're looking at the position. So, I mean, your ladyship's absolutely right. There's the two. If you go to 240, section 240, subsection 2,
Yeah.
there's the two possibilities in lim A and B, and it's sufficient for an applicant to establish either. So lim A is effectively that you're insolvent immediately prior to giving the preference, and lim B is that you're insolvent in consequence of the preference, and either is sufficient.
But where does it say immediately before? Because it says when a company, blah, 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 gives a preference.
Well, it must, isn't, I think it must
that
be implicit.
That time is not a relevant time unless it is at that time. So what is the exact point in time at which the preference is given, I suppose, is the question.
Well, I think, I mean, the way, I mean, I've always read this is obviously B is looking at the position in consequence of the preference, because that's what it says expressly. So implicitly A is looking at something else, so i.e. the position immediately prior to the preferential act.
Well, no, they'd look at two different things, because it's either at that time unable to pay or becomes unable to pay in consequence of.
So at that time is the giving of the preference, so.
Yes.
Yes.
It's only what the judge found was balance sheet insolvency immediately before.
Yes, that's all she found. So it was put on a number of different bases, as I say, the liquidator's entitled to do that. But importantly, there was no finding of insolvency in consequence of the preference. Now, I'm just going back to our point on this. I mean, either you look at it on the basis Comet's going to remain part of KISA, you're looking at the position prior transaction on the footing that remains part of the group, in which case it's obviously not insolvent, we would submit, because KIL is not going to demand on the RCF so as to make it insolvent. If you're looking at it on that footing, not insolvent, if you're looking at it on the footing that, well, a demand is going to be made as part of the transaction, the answer to that is, well, Comet's going to be able to pay that, it does pay that, and it comes out of the transaction in a solvent position. And on either footing, we, with respect to the judge, don't understand how she can conclude, essentially on the basis of treating the KIL RCF as a presently due liability of £129 million that Comet was insolvent.
Now, let's see what she does say, shall we?
Well, how she deals with this, we just go to the section.
135.
Yes, it's slightly earlier on in the judgment. So, and it's it's essentially paragraph 168. And paragraph 168, I think in the first two sentences, deals with my submission. And as we then made the point, which I've made also, to your lordship, in my lordship, that following the disposal of the transaction, in fact, improved Comet's balance sheet. And then 169, she says this: I agree with Mr. Gledhill that we're wrong to regard an on-demand loan as it is a contingent liability. It's clearly an actual liability. Well, it doesn't really, in my submission, deal with our point, which is that you have to look at whether this liability is actually going to be something that is demanded upon, so the company, in fact, has to be able to pay it.
Well, she says that she says that at 170, doesn't she? The likelihood of support is relevant. And then she says, in effect, that Keyser wanted to cease to own Comet on terms of finding. I mean, your answer to that is that doesn't necessarily make Comet insolvent if it funds the repayment of the Kill RCF from a different source, as it did through the Hell RCF.
And it comes out solvent as a result of that transaction, which is, in our submission, the critical point. And in fairness to the judge, you also, I think, should look at 176, although this doesn't actually deal with our point in relation to the Kill RCS specifically, because she says 176. My overall assessment of the evidence is that Comet was balance sheet insolvent within 1232 immediately before the disposal. So that's obviously the position she's looking at. It's immediately prior to the preference being given, notwithstanding the new board's determination that it was not. So if she disagrees with the new board, as I indicated earlier, there's no evidence of a detailed scrutiny of the position by the new board, and realistically it's likely that they focused on cash flow insolvency rather than balance sheet insolvency. So that's a sort of inference she draws. I have determined that the DTA, deferred tax asset, should not be taken into account. Well, we don't dispute that, but that the Kill RCF should. And in our submission, that was wrong, simply to take it into account at the full 129 million.
In 179, the judge leaves open, does she, the post-transaction position?
Yes. And one of the, this sort of, in fact, neatly illustrates the difficulty of approaching it on an accounting standards basis, because post-transaction there were two balance sheets. One was prepared under IFRS, one was prepared under GAAP. And depending which one you looked at, the company was solvent or not. And that, we regard it as supporting our point. You can't treat this just as a matter of accounting standards. You need to look at it in a real-world way.
But hasn't she asked the wrong question in 179? Because the question isn't whether it's balance sheet insolvent in consequence of the disposal, but in consequence of the preference, if
yes.
it was a preference.
That's correct. It may not matter in the sense that she she declined to make a finding that it was insolvent in consequence of the preference.
And she didn't deal with the question whether it was insolvent, full stop, after the disposal.
No, she declined to.
Yeah.
In essence, she declined to deal with that, and that was, as I understand it, on the footing that she decided it on the basis pre-transaction. That was enough for the preference, and we don't have a respondent's notice trying to uphold it on any other basis.
I mean, if she had concluded, well, look, post-transaction, it was obviously insolvent, then your argument about the need to discount the kill RCF pre-transaction would have looked a bit hollow.
Well, it would, but I mean, I suspect we wouldn't be. I mean, I'd be in difficulty anyway because of her finding that it was insolvent post-transaction, unless post-preference, unless I was able to challenge that. So, yes, I mean, it certainly did improve the balance sheet, the transaction, because of the liabilities that were taken off it. So, I mean, that is essentially our point on balance sheet insolvency. I mean, we also make, there's a very similar point which we make in the skeleton in relation to some of the long-term liabilities over 1 year. I mean, it's essentially the same point. Those liabilities are much smaller. They're not, I think, material. I mean,
Well, you say they should have been, quote, appropriately discounted.
Yeah.
There's no evidence, is there, on what the appropriate discount
Well, it's, I mean, a question whether it's a matter for expert evidence or whether it's a matter for the court to form a real-world view of, is the evidence I've been given enough to enable me to conclude that this company can reasonably expect to meet its liabilities or not. If you're dealing with liabilities that are only payable years in the future, then those are less probative of current insolvency than liabilities that are due now, and you have to sort of look at it ultimately in a real world way. I mean, I think it goes back to our main sort of point on this, which is it's not a mechanistic balance sheet accounting exercise. It's a real world question, and the balance sheet is a tool to help you answer that question rather than an answer.
But you would accept, as I understand you, that this ground of appeal really turns on the kill RCF because the other things wouldn't be enough on their own.
Exactly, they're much smaller. Given, I mean, the judge didn't give us permission to appeal on some of the elements and of the debts over 1 year, and what's left is by itself, I think, not material to overturn the deficit once you deduct the deferred tax assets. So the one that matters is the kill RCF, which is obviously huge in the balance sheet context.
And there you've got to discount it really a lot. I mean, you say you discount it to zero, do you?
In effect, yes, or very small. But in my submission, that's exactly right, because I mean there was zero prospect of it being demanded on, and we know as part of the transaction it was in fact repaid.
So can I just check one point? Just
Yes, of course, my lady.
I've understood your submission, Mr. Smith, please. So you don't quarrel with the judge's decision, which she expresses in para 176, first sentence, to examine the position immediately before the disposal?
No, I don't quarrel with that. I mean, that's how I'd understood
all right.
242A to work in effect.
Yeah.
So,
okay.
So we're not quarrelling with the way we're not quarrelling with the question she's asked herself.
No.
We just aren't quarrelling with the way she's answered it.
Sure.
Your Lordship will bear with me. Thank you. Unless you have any questions for me, those are our submissions at this point.
Thank you very much.
Thank you.
Yes, Mr. Gledhill.
Just give me a moment just to arrange myself. I'm going to deal first with the issues raised by this appeal, as Mr. Smith has done, in relation to desire to prefer, and then deal with balance sheet insolvency. I suspect I won't get to balance sheet insolvency until some point tomorrow morning. But before I address those two substantive topics, I did want to start, if I may, with some brief preliminary comments. At the consequentials hearing, the judge expressed hesitation about giving Darty permission to appeal, given that her conclusions on both desire to prefer, and balance sheet insolvency were heavily conditioned by findings of fact made having seen extended cross-examination of both fact and expert witnesses. And in light of that, as the court has seen, we began our skeleton argument by reference to the well-known series of authorities in relation to the appropriate approach in this court, where what is in substance before it is an appeal on a point of fact or an evaluative decision. And we did that principally by reference to two decisions which were then the most recent ones in this court, a case called Kynaston Mainwaring and a case called Deutsche Bank and Sebastian Holdings, which in turn summarised the case law that had gone before them. I'm not proposing to take you through those very familiar principles at any level of detail, but I did want to start, if I may, by just instancing one point which we can conveniently get from the decision in Deutsche Bank, which you find in volume 4 of your authorities bundle at tab 34.
Volume 4, right.
The decision is a decision of Mr. Justice Mayles. The facts don't matter at all. And if you have a look at paragraph 50, starting at paragraph 50 on authorities bundle page 1109, number at the bottom right. In fact, starting at paragraph 48, you can see there's a summary of the preceding case law in relation to appeals on points of fact. And at paragraph 50, his lordship refers to a decision of Lady Justice Carr in a case called Walter Lilly. And if you turn on a couple of pages until you get to bundle page 1111, you should have at the top of that paragraph 87 from her ladyship's decision in that case, and I'll just read that. The degree to which appellate restraint should be exercised in an individual case may be influenced by the nature of the conclusion and the extent to which it depended upon an advantage possessed by the trial judge, whether from a thorough immersion in all angles of the case, or from first-hand experience of testing the evidence, or because of particular relevant expertise. And we say that all three of those considerations apply here, and I particularly wanted, if I may, to draw out that last comment, the reference that Lady Justice Carr makes to the particular relevant specialist expertise of the first instance judge. And I say that for this reason. At trial, it was Darty's case that this was a perfectly ordinary mergers and acquisitions transaction. It said that the decision to repay the Kill RCF had been taken by the three members of the new board at completion, two of them having, as you've seen, been appointed a notional few moments before making that important decision. And it said that the new board's decision to clear the intercompany debt by repayment, rather than by any of the other alternative means that were available, reflected first of all standard M&A practice, and secondly the fact that bids for Comet had been solicited by KISA from the outset on the cash-free, debt-free basis. And my learned friend's skeleton arguments for this appeal still maintains that first proposition. You see that if you take out their skeleton. And if you look at, I'm afraid I don't know what version you have it in, and the paragraph numbering has changed as a result of its being refiled last week. But I think it's paragraph 38 sub 2 in the refiled version.
Yeah.
It starts with the words, Darty does not challenge the primary findings of fact. And you see that little 2, it says the settlement of intercompany indebtedness is conventional in a corporate M&A transaction, since the seller group will not wish to be commercially tied to the sold entities. That provides a sufficient explanation for why intercompany indebtedness was discharged as part of the transaction. Now, everybody agreed at the trial before Mrs. Justice Falk that this was a formidably complicated M&A transaction. The evidence showed that it ultimately involved approximately 200 separate transaction steps. And having practiced as a corporate lawyer with a leading city firm for 30 years, the trial judge in this case was particularly well placed to get to grips both with the complexity of that transaction and to evaluate the submission made by Darty that this was a perfectly ordinary deal. And having done that, she reached the clear conclusion that it was anything but the ordinary transaction which Darty claimed it to be. I can invite you to take the judgment out again at tab 6 of the core bundle. And I'll start, if I may, by reminding you of 3 passages in that. So the first one at bundle page 113. Looking at the judge's paragraph 113, looking at the judge's paragraph 13, she said, after initially taking strategic advice from Lazard's, Keyser turned to Bank of America Merrill Lynch. Skip a couple of lines. Shortly thereafter, an information memorandum was issued to interested parties with first-round offers being invited on a cash-free, debt-free, cash-free basis. I pause here to note that all this means is that pricing should be on a basis that ignores existing debt and or cash in the business. The idea is to obtain an enterprise value. It says nothing about what the financial structure will actually be. So that dealt with what was in fact pleaded as being one of the primary points in Darty's defence. And turning on to bundle page 155, you have paragraph 209, which you've looked at with Mr. Smith, but it's an important paragraph in the context of the judge's wider evaluation. Leaving Comet's funding position to one side, the SPA and completion agreements could have been structured in a number of different ways to achieve the same overall economic result. The most obvious thing to do in a dowry sale, where the debt is clearly underwater, would be to capitalise or waive all debt owed by the selling group and transfer the shares for a nominal sum with the agreed dowry being paid. An alternative would be to assign the debt for a nominal sum rather than waive or capitalise it, but otherwise take the same steps. I note that Valco were the only other bidder other than Not Capita, which submitted a second round bid. I note that Valco's first round offer and at least one of the alternatives offered in the second round were premised on an assignment of debt, and Not Capita's first expression of interest referred to the acquisition of intercompany receivables owed by Comet. So that's important because what the judge is saying there is that in the context of a dowry sale, a provision providing for the repayment of the intragroup debt in full is an unusual thing to have done. And
do we get an explanation of why it was done this way rather than the other options being taken?
Well, there are, my lord, the answer to that is we do. And there are 2 explanations for that. And
to be found in the judgment?
To be found in the judgment.
Yep.
There is a structural explanation, which is that, backing up a bit, it was fundamental to the viability of Comet's business that it retained the confidence of credit insurers. And there was evidence that if credit insurers pulled cover, Comet became a much more liquidity-intensive business. And in the immediate aftermath of the signing of the share purchase agreement, this is in the judgment, I can give you the references in the morning once I've written them down, there was a roadshow in which both Not Capita and Comet management went out to the credit insurers and said, you have nothing to worry about because there's £120 million of liquidity in the new structure as the result of the way in which this has been done. And what her ladyship found was that they got to that result in large part as the result of the circular funds flow at completion, by means of which the Kill RCF was repaid.
So just interrupting for a moment longer, so that wouldn't suggest of itself that the mechanism that was adopted was designed to improve Keith's position. From Keith's point of view, it was good enough to adopt one of the other options to the same economic effect.
That is correct, because as I indicated, there are two different reasons for it.
Yes.
And that is the second one. Assignment, well, first of all, waiver, forgiving the debt, capitalisation, swapping the debt for equity, or assigning the debt for a discount, or perhaps for zero to the purchaser. None of those achieve the result of securing a repayment of the group treasury company KIL. And that is the second reason.
I'm not sure why that matters. I mean, if from the group point of view you can achieve the same economic result by one of these other mechanisms, that's fine.
But from the group point of view, dealing with the second point, the impact on KIL. The impact on KIL is very different if KIL's debt is waived. It's fundamental to appreciate that there was originally proposed to be an appeal from Her Ladyship's decision on the basis that she was incorrect to find that there had in fact been a preferential effect as a result of this transaction. She found that there had been, albeit that the funds flow is circular, albeit that the funds flow is in certain respects highly synthetic, this was a real movement of money to KIL. And it was a real movement of money to KIL, in effect at the expense of Comet's unsecured creditors. Because the starting position before the transaction is that Comet has an unsecured line of credit for in the region of £300 million, with roughly £129 million owed as at the transaction date. The position immediately consequent upon the transaction is that it has a secured liability to HAL. In other words, that £115 million that came out and was secured effectively against Comet's stock is no longer an asset available to Comet's creditors.
I mean, I follow that, but I'm just trying to understand what one can infer from the fact that the parties adopted this mechanism as opposed to the other mechanisms that the judge thought more obvious. Now, one possibility you've explained is that they wanted to be able to present an attractive picture to credit insurers, but that in itself doesn't seem to involve trying to improve Keith's position.
I accept that.
So I'm just trying to understand, why does anything to do with KIL involve a different picture?
Because KIL is repaid a real £115 million.
Quite, but from the point of view of the group, it's in exactly the same position, isn't it? So why does it matter if this particular company has changed its position in some way?
It's not in the same position, because in the event that it's not repaid and the debt is waived or capitalised,
yes,
it has a £115 million liability in KIL, which would have to be written off.
Well, if it's been waived, it's obviously being written off.
Yes.
If it's being capitalised, it's obviously being written off. If it's being assigned, it's no longer KIL.
Yes.
So fine, those things were all possible and they achieved the same economic result.
They do.
So when we're struggling to infer why they adopted this mechanism, what's the answer?
The answer is because real cash moves to KIL.
But why would they be bothered about that if they could achieve the same economic result in a different way?
Because it's not the same economic result.
So why isn't it the same economic result?
Because £115 million of cash moves to KIL.
But from the group's point of view, we're going over the same ground. I'm afraid I haven't grasped why there's any difference from the group's point of view.
I'm not sure I'm following your lordship's point, and it may be that I need to reflect on it overnight and come back on it. But the position pre-transaction is that KIL is owed a substantial debt, and Triptych is a substantial debtor to KIL. And what is done effectively is that those amounts are expunged, leaving KIL £115 million better off than it otherwise would have been.
From the group's point of view, they were going to put in a net 38 million.
Yes.
they could achieve that result in more than one way. They
Yes.
chose to, or the parties chose to achieve it in this particular way. Do we know why they chose that as opposed to one of these other ways? Because seemingly, from a group point of view, it achieves exactly the same.
There is a real movement of money. There is a real movement of money that leaves the unsecured creditors of Comet worse off, and the beneficiary of that is Kill. Before the transaction, the unsecured creditors of Comet are in a position where the assets that were caught by the Hull floating charge, it was common ground below, was effectively Comet's trading stock. That was the valuable asset. So immediately prior to the transaction, the unsecured creditors of Comet, in a Comet winding up, would have had access to £115 million, or whatever the figure was, of Comet's stock in trade waiting to be sold in its shops. The position afterwards is that they have lost recourse to that. And the direct corollary of that is because £115 million of real value has moved to Kill. I accept that, as my learned friend makes the point, that repayment, as well as waiver or assignment or capitalisation, all result in a clean break. But they don't produce the same economic effect vis-à-vis the creditor Kill. Kill gets paid real money in this world. And the reason for the judge's decision, a large part of the reason for the judge's decision, as I've indicated, first of all, she made the point that the structure that was adopted was necessary to be able to present to credit insurers the suggestion that Comet had £120 million of new liquidity. In fact, just pausing there, she found as a fact, and it was undoubtedly right, that not a penny of that went to Comet, because the money simply went around in a desktop loop at McFarlane's, with slightly different proportions coming out to Keyser and to Capital that went in at the beginning. But plainly, the counterpoint to the fact that the unsecured creditors were left with a claim against a company whose assets were now predominantly subject to a charge was that there had been a real shift in value. And that real shift in value was a shift in value to Kill. Its debt was repaid. I accept that in practical terms, that is a clean break in the same way as either an assignment or a capitalisation or a write-off is. But it is, I respectfully suggest, an error to say that it follows from that economically vis-à-vis the creditor, the position is the same. It's not. One is achieving a clean break by repaying the company debt. The other is effectively achieving a clean break by waiving it. And the point which Her Ladyship is making in paragraph 209 is that where you have a dowry sale, where effectively you're saying to the buyer, I'm going to pay you money to take this company off my hands. The reason for that, as she says here, is usually that the debt is underwater. And if the debt is underwater, the conventional transactional technique is either to waive or capitalise, or assign at a deep discount or perhaps for nothing to the purchaser. But they elected to do something different. They elected to pay. And that's the point I think the judge is making in this paragraph. Does that answer your lordship's question?
I confess I'm still puzzled, but maybe nobody else in court is, so I keep going, Mr. Bethill.
Right.
I think I'm following it. I say that with hesitation because, as you've probably gathered, this isn't my field at all.
I was going to show you 3 passages in the judgment, and just to remind you, I'm dealing at the moment with the question of whether or not the judge was entitled to conclude that this was the vanilla M&A transaction that it was represented as being by Darty in their case in opening below. Turning over the page to bundle page 156, you see what she says at paragraphs 214 and 215, where she says, I have no doubt that Mr. Enoch was clear throughout the discussions that apart from the modest level of capitalisation agreed, and just pausing there, the original debt is 129 million, and 13 million is written off, 115 million is paid. apart from the modest level of capitalisation agreed, intercompany debts would all be settled at completion. 215, however, Mr. Enoch is a lawyer with obvious experience of corporate finance transactions, including buying and selling subsidiaries. He must have been well aware that this was far from a routine sale, where intergroup debt repayments to the selling group form part of the value received. So, drawing upon her transactional experience, the judge below rejected Darty's case, repeated in the passage of the appellant's skeleton argument I showed you a moment ago, that there was nothing out of the ordinary on the facts of this case in the decision to repay kill as part of the sale transaction. And importantly, for the purposes of this appeal, she also went on to conclude that the papering of that decision, so as to show it being taken by the new board at completion, was a device to mask the fact that the real decision was taken here by others well before. And I'll take you to 4 passages in relation to that. The first is back at bundle page 126, paragraph 68, and if you just turn back a page, you can see that this is the last paragraph of her commentary on Mr. Enoch and the impression he made as a witness. And she says at paragraph 168, my overall impression is that Mr. Enoch took a somewhat blinkered approach to the transaction, concentrating on Keyser's position and the objective of a clean break and seeking to ensure that Keyser was distanced from the formal decision.
168, did you say?
Sorry, paragraph 68.
68?
I'm so sorry.
I beg your pardon.
I misspeak.
I'm looking at the wrong paragraph.
Page 126. Page 126, paragraph 68. Impression is Mr. Enoch took a blinkered approach, concentrating on Keyser's position and the objective of a clean break, and seeking to ensure that Keyser was distanced from the formal decisions that the Comet Board would be required to make to allow the disposal to complete. As discussed further below, I also do not accept that Mr. Enoch's recollection of a lack of involvement in the debt repayment mechanics reflects the full picture of what actually occurred. And then if you turn on, please, to bundle page 161, and look at paragraph 239, Her Ladyship said, as a formal matter, no decision was required to be taken by Comet before at the time the SPA was entered into on 9 November, because Comet was not a party. However, the SPA was explicit about what Comet would be required to do. Although the SPA contemplated the new board would, quote, review the financial position of the company prior to completion, no provision was included to cover the possibility that it might find it to be unsatisfactory. Given the care usually taken in detailed documentation to cover the risks of anticipated events not occurring, I infer that the possibility of the new board not falling into line was not considered to be a real risk. I'll come back to that.
I'm so sorry, Mr. Glover, I didn't get the paragraph reference.
I'm so sorry.
No, it's my fault.
Paragraph 239,
239.
bundle page 161.
Thank you.
And Mr. Smith had some comments about that. I'll come back to that in due course. Moving on now, please, to bundle page 163. Paragraph 248, and another passage in which you see the judge bringing her own experience to bear on this transaction. She says this: by the stage of the disposal was due to complete, KEP had, as the SPA contemplated, undergone the very public process of seeking and obtaining shareholder approval to the disposal, while the carefully choreographed documentation appears to leave it to the new board, note this, unusually appointed immediately before rather than at completion, to take the necessary decisions on behalf of Comet, so distancing the process from Keyser. The real decisions were taken much earlier. The new board were expected to play ball or be sacked and be replaced by people who would. And then final passage on bundle page 169, paragraph 274. In the circumstances of this case, I do not accept the relevant decision was taken by the new board on 3 February. The substantive decision to repay the KIL RCF was taken on Comet's behalf when the SPA was signed. What occurred on 3 February was a formal, albeit necessary step. And then down to the last sentence, what I have described as careful choreography to distance Keyser from formal decision making was not effective. There is no appeal before this court against the judge's conclusions that this was not the ordinary mergers and acquisition transaction that Darty claimed.
Can I just ask you, before you go on,
Sure.
just explain the last sentence of paragraph 274?
Yes.
Careful
Now,
choreography to distance Keyser.
yes.
Why Keyser?
Obviously, I'm trying to infer what may have been in the judge's mind, but I think I can help your lordship with that question. There was evidence at trial that McFarlane's were the solicitors for Op Capita, the purchaser. And there was evidence at trial from a memorandum prepared by McFarlane's that careful consideration had been given by the sellers, Keyser, and the buyers, Op Capita, to the potential application of the clawback provisions of the Insolvency Act in relation to this transaction, including consideration in relation to whether it might be caught by Section 239. So what I suspect the judge is referring to there is that the structuring that was put in place in an attempt to immunise this transaction from the Insolvency Act's clawback provisions had not been effective. And there were a number of possibilities. One of them was the potential for claims against Op Capita under Section 245 on the basis that it hadn't given value, Hull had not given value for the floating charge. And there was obvious potential for claims against the transacting parties under Section 239 in relation to preference, but Op Capita, being the solicitors to the purchasers, effectively said, that is not our problem, because we are not Comet. So I'm speculating, but my understanding is that that is likely to have been what is in the judge's mind when she made that comment there.
So I'm so sorry, Mr. McFarlane's were acting for...
McFarlane's were the solicitors for Op Capita, and my lady Op Capita's purchase vehicle was a company called Haley Acquisitions Limited. How? Slaughter and May were acting for Keyser, and the document that I mentioned was in fact a memorandum prepared by McFarlane's for Op Capita, and it expressly referred to the possibility of a Section 239 claim being made in relation to this repayment, but said that that was effectively Comet's problem, not Op Capita's problem. So the judge has reached the conclusion that this was not the usual M&A transaction that Darty purported it to be, and that the interposition of the new board, as she says, unusually prior to completion, because ordinarily you would expect the new board to be appointed by the purchaser after completion of the share sale has taken place, was part of a colourable device to hide the reality of what was going on here. And as the judge also found, the seller, Keyser, and Op Capita, the buyer, did very well for themselves out of this process. Keyser averted the serious reputational consequences it would have sustained had Comet gone into an insolvency under its ownership. At a fraction of the cost, figures are in paragraph 21 of the judgment, of 200 to 470 million pounds, that it thought it would have to bear had there been no sale. For its part, Op Capita made a clean profit the moment the deal was signed, and without putting a penny of its own capital at risk, of £151 million, representing the £36 million dowry that it was paid, plus a £115 million secured loan which its purchase vehicle, HAL, got over Comet's stock at completion. And that, for your reference, is paragraph 48 of the judgment. And that £115 million gain to HAL, as I explained a moment ago, was the direct product of the loss to unsecureds, because there was nothing left in the kitty when Comet went under 9 months later, leaving them, prior to these proceedings, with a dividend of 0.18 pence in the pound.
Can I revert to the point at which I expressed puzzlement? So, if I've understood what you've just said, the party that improved its position by having this mechanism was Op Capita.
My lord, there was a lively debate about that at first instance. And one of the points that was run by Darty by way of defence was that there was either no preferential effect, or that if there was a preferential effect, the party that had actually gained the benefit was Op Capita and not Kill.
But you say both got a benefit from it.
Certainly Op Capita got a benefit as well. But we had an argument about that before the trial judge, and she rejected that submission. That point went to the question of whether there had been a preferential effect in favour of Kill. And there is no appeal before this court on that.
And I followed that. I think this is a bit of a red herring, but while I'm on my red herring, from Keyes' point of view, they wanted a deal under which they put in 38 million and had no outstanding liabilities. And they were out of it. And that could have been achieved in a number of ways. In the event this particular mechanism was chosen, and you've explained that substantially improved Op Capita's position. If one's trying to work out why Keyes would have adopted this mechanism rather than another mechanism, it isn't obvious to me that they improved their position in a way that accounts for their choice of mechanism, whereas Op Capita seems to have had a very good reason for adopting this mechanism.
Well, can I perhaps express it this way? So, your lordship takes as a given that the Keyes dowry is £36 million. That the Keyes dowry is £36 million because Keyes knows £115 million is coming back into the company. And in fact, the alternative bid, which was not pursued by Keyes, was a bid from a company called Valco. It was the distressed retail arm of Hilco, the well-known restructuring specialists. And Op Capita's bid, in fact, prevailed over Valco's because Valco wanted a dowry of £145 million. Now, if you add the £36 million that Keyes had to put in to the £115 million that it took out, you get to a figure that is not very different to that. So the answer to your lordship's question, I suggest, is the dowry, as it happens, was a dowry of £36 million. But it was only a dowry of £36 million because Kill was getting £115 million in cash. Does that address your lordship's question?
So in other words, you're saying that Kill and Op Capita benefited from this structure in different ways?
Yes.
Yeah.
And in fact, that is a point her ladyship makes at a number of points in the judgment. That there is, in fact, a community of interest, a synergy of interest between both Op Capita and Keyes, in which the interests of Comet were entirely ignored and not even really asserted until roughly 2 weeks out from the completion date, when for the first time, because they asked for it, they got independent legal advice in relation to this transaction. So those are the preliminary comments that I wanted to make. And I'm now turning to the first issue, which is the question of desire to prefer. And there are three broad topics under this heading. The first is the question of whether or not Mrs. Justice Falk was entitled to find that a decision to repay Kill was taken by Mr. Enoch on or before the 9th of November 2011, when the share purchase agreement was executed. The second is, if so, whether the trial judge was right to hold that Mr. Enoch was acting for Comet, such that his decision was Comet's decision. And the third question is, if so, whether the trial judge was right to hold that Mr. Enoch had desire to prefer. And analytically, it's helpful to address the question in those three stages, but I make an important and fundamental point at the outset, which is that the first two questions are inextricably connected. And I'll come back to this, but what the court is confronted with in the first instance judge's judgment is an inferential finding based upon the totality of the evidence before her. It is, we respectfully submit, an error of principle to pick some individual element in that and say, well, that doesn't prove very much about whether Comet took a decision. The real question is whether the totality of the evidence, the totality of the considerations which the judge had present to her mind warrant the inference that she drew. And in relation to that first question, whether or not there was a decision at the date or before the date of the SPA, it is a fundamental point that she found that Mr. Enoch was acting for Comet. I'll come back to that. So, dealing first with that first point, the date of the decision. The key paragraph for that purpose is in the judgment is paragraph 162. No, I'm quite wrong about that. It's bundle page 162, paragraph 245. And the judge said in that paragraph, in the very particular circumstances of this case, I consider it would be too narrow an approach and effectively a triumph of form over substance to find that there was no decision by or on behalf of Comet at the time that the SPA was entered into, because it was not formally a party to that document.
Well, what is the decision that she's talking about?
I will come on to that squarely in a moment, but at one point during the course of my learned friend's submissions this morning, my Lord Justice Newey put it to Mr. Smith, or in discussions with Mr. Smith, canvassed this point. Was it a decision in Mr. Enoch's mind? It's absolutely fundamental to an understanding of this decision.
No, I'm not. That's not quite my question. I mean, was it a decision that the SPA should be signed in the form in which it was, or was it a decision that Comet would repay the Kill RCF, or was it some other decision? What is the decision that the judge is talking about here?
Well, I'm going to come to that, if I may, after having a look at some of the authorities with your lordship, but I think this harks back to a point which my lady made during the course of the morning on looking at the section. What is the decision? And many of the submissions on Darty's side of the argument proceed on the basis that the court has to identify the decision at some particular point, some particular moment. The reality of the decision, in this case perfectly exemplifies it, is that there may be situations in which the decision is effectively a cumulative or an incremental process. So I decide that X will happen if the following conditions subsequent fall into place. For example, if the shareholders approve. I decide that Comet will repay if the new board at completion takes the formal decision that I anticipate they will and sanctions that. I'm going to come back to that, if I may, after having had a look at some of the authorities with the court. Does that sufficiently address your lordship's point for now? I will come back to that.
Not quite sure that it quite bottoms it out, but it's good enough for now.
If I haven't bottomed it out,
Is it? I mean, you're probably better waiting, but I rather infer from what you've just said that you say that there was a decision that Comet would repay if certain conditions were satisfied.
Yes. There was a commercial decision that Comet would repay.
Well, yes, but doesn't it depend on what the conditions are? I mean, it's one thing to say, taking an example far removed from this case, I will buy a piece of land if planning permission is obtained, and I will buy a piece of land subject to contracts being exchanged. They're two completely different conditions, and the one might well have a different legal effect from the other.
I understand your lordship's point. Let me take, I'm going to show you the court a series of 3 cases on this point and make some submissions in light of those, and that may assist with the point which I think is troubling your lordship.
Can I just take you one moment longer? In answer to my previous question, you said a commercial decision. Well, what does that mean? What does a commercial mean?
A practical decision subject to defeasance in the event that the new board were to determine that they simply were going to reject the entire transaction. Because
But does practical add anything? I mean, either there's a decision or there isn't. It may be taken for commercial reasons or practical reasons. But it's your case, there was a decision that Comet would repay these sums if certain conditions were satisfied, or at any rate if there were no defeasance. Is that right?
yes. Let me take the court to the decisions that I wanted to show you. So, at first instance, we took her ladyship to a decision called Travel Brothers, which we in fact have in the bundle of authorities. That was in fact a decision under Section 44 of the Bankruptcy Act 1919, which was the predecessor decision. So I'm not going to take the court to that, because in fact all that ultimately shows the court is that you can have a situation in which one person affects the payment, one person gives the preference, but that the relevant state of mind, desire to prefer as we would now term it, is in somebody else. But I accept that is a decision on a different statute, so I'm not going to take up time showing it to you. But I am going to show you an authority which I suggest comes to very much the same thing, and it is an authority of this court under the 1986 legislation. And you find that in volume 1 of the authorities bundle at tab 11. It's a decision in a case called Katz and McNally. It's sometimes reported as Re-Exchange Travel, which was the name of the company. And on the facts of this case, it was concerned with a travel business which owed loans to its directors, who were 2 members of a family called McNally. In April 1990, the McNallys decided to try to sell the company, and in July 1990, their director loans were cleared. The McNallys, the directors, didn't make the payments themselves. Instead, what happened was that they told the finance director, who was a man called Jeffries, and another employee called Atkinson, to make those payments, and they duly did. But the hoped-for sale fell through. So in September 1990, 2 months after the payments had been made, the company went into administration, and the office holders thereafter brought a claim seeking to set aside the repayments as preferences. And if you move on to bundle page 169, just above letter E, you can see that one of the arguments that the McNallys ran in answer to the preference claim was that the repayment was simply a necessary tidying up exercise in anticipation of the abortive sale. Just above E, the third way in which the presumption was sought to be rebutted was by an attempt to show that Mr. Jeffries, that's the finance director, caused the repayments for the purpose of tidying up the group's accounts preparatory to the sale of the travel business. And then moving down to the bottom of the page, final paragraph, you can see another argument which has resonances with the arguments that Darty mounted below. Second line of that final paragraph, Mr. Cogley submits that the judge proceeded on the basis that the state of mind of Gordon and Sylvia McNally was the state of mind of Holdings. That, he says, was not justified, as they were merely creditors requiring payment. He says over the page that the important persons who represented Holding in performing the mechanics of the repayments were Atkinson, Jeffries, and a man called Elliot. But reading further down that page, you see that Lord Justice Peter Gibson rejects both of those arguments. Just above letter D, you can see a sentence starting, Mr. Cogley points to Mr. Atkinson's evidence that he had no intention to prefer. Skipping down a couple of lines just beneath D, in my judgment, it is impossible to say that because a signatory merely doing what he's been asked to do, and with no knowledge of the accounts, had no intention to prefer, therefore the presumption is rebutted. The judge was bound to consider who in the company had initiated the payments, and whether the initiators were influenced by the desire mentioned in subsection 2395. And then in the next paragraph, there's reference to the evidence from Mr. Jeffries. He was the finance director. 3 lines up from the bottom, just above letter F, it says Mr. Jeffries didn't intend to prefer the McNallys, is, as the judge held, of no importance, given that he acted on their instructions. And he quotes the evidence, and then looking down to the final paragraph on that page at letter H, in the circumstances when so plainly the initiators of the repayments were Gordon and Sylvia McNally, acting not only as creditors but also as directors, it seems to me wholly unreal to leave out of account the part they played in causing the substantial repayments to themselves by Holdings at a time when it was known to them that it and the group were in serious financial difficulties. Now, on one level, the analysis in this case is confined to the question, is the decision to pay influenced by the desire? And the decision is the decision taken by finance director and the company secretary when they sign the check. And Lord Justice Peter Gibson is saying that's plainly been influenced because the directors told him what to do. Another way of looking at it would be to say that the directors took a decision and there is then a separate decision to execute that instruction to make the payment. And that takes me to the next authority, which is back at tab 9.
Sorry, why does that help us?
Because that question, so there are 2 ways of looking at that problem. The case I'm just about to show your lordship, and in fact the next case, which is a decision of Mr. Justice David Richards when still at first instance, are cases where the dividing line between those 2 ways of looking at the problem is much starker, because there's a significant difference between an original decision to make a payment and the execution of that decision.
Yes, I see. So you say on one view this helps where you've got 2 decisions.
Yes. My Lord may remember that there is we're going to come to MC Bacon in a moment. I'm sure it's a very familiar decision. My Lord may remember that there was some discussion, it was the first significant decision of principle on section 239 after the passing of the 1986 Act by Mr. Justice Millett, who of course understood it intimately because he'd been on the court committee. And there was a discussion in that about whether you assessed desire to prefer. That case was concerned with the granting of a charge. And there was a question about whether you assessed desire by reference to when the decision to grant it was taken or when the grant was executed. And there was a subsequent decision, which doesn't matter, called Fairway Magazines. There are then these 2 decisions. This is the first, Mr. Justice Lloyd, which considers that question, where there is, if I can put it this way, a flash-to-bang time, a lag between the decision and the payment. When is the relevant decision? What is the relevant decision for the purposes of Section 239 claim? So Mr. Justice Lloyd's decision is, and this is important, it is a decision from a county court judgment, where as far as the report goes, there's been no cross-examination of of anybody. And in this case, it was very much the key question whether there had been one decision or two. Again, this was a preference claim concerning repayment of directors' loan accounts. And on the facts, what had happened here was that the company's board had resolved in January 1994 that those loans would not be repayable for a year. And they made that decision for the purposes of obtaining audit sign-off. So the loan accounts were always repayable, but in January 1994, a decision had been taken in effect to make them non-repayable for the period of a year. The repayments were then duly made a little over a year later at the start of February 1995, only a matter of days before the company ceased to trade and went into CGL. And when the liquidator brought a preference claim in relation to the repayments, the directors argued that the only relevant decision had been the decision taken in 1994 by formal board resolution. And it was their case that at the date of that resolution, they had not been influenced by desire to prefer. And you see what Mr. Justice Lloyd makes of that submission if you turn on to bundle page 144. You looked at this briefly with Mr. Smith. I'm going to read you a slightly more extended extract, if I may. Starting just above letter C, do you see a sentence starting, however, I do not accept? However, I don't accept that January 1994 was the date by reference to which it is appropriate to consider whether, in giving the preference that undoubtedly was given, the company was influenced by the relevant desire. It seems to me that all that happened in January 94 at most was that loans became repayable in January 95. A lot of debts were repayable by the company in January 1995, and a lot of them were not paid. The fact that the directors' loan accounts were repayable in January 1995 does not lead to the conclusion that there was not a relevant decision to give the preference by actually paying those debts. It seems to me that the relevant decision to make the payments was, and could only have been made at the time or immediately before the time when the cheques were drawn, that is to say on 2 February and 6 February, even if, as I'm prepared to accept for present purposes what passed in January 94, meant that there was an obligation on the company to pay in 1995, it was necessary for the board to review at that time whether to honour that obligation. Now, my Lord Justice Lewison put it to Mr. Smith in the course of his submissions, well, isn't this just a decision on its facts? And so indeed it is. But the reason that I cite that decision to the court is what you have here, and I say again, there is no cross-examination, this is all done on the basis of affidavit evidence. There is a formal board resolution, which is incontrovertible, taken in January 1994. And what Mr. Justice Lloyd is doing here is inferring that there must have been a separate decision taken in February 1995. And that was tainted by desire to prefer, and that was the relevant decision. And just looking back between letters D to E, you can see that, in fact, the evidential basis for that inference is, in fact, I intend no discourtesy, but it's comparatively slight.
It's what?
Comparatively slight.
But somebody had to initiate the payment.
Yeah. Yes.
And indeed, that's referred to in the next paragraph.
Precisely.
In my view, only when the cheques were signed by the authorised signatory did the company decide.
Precisely so.
So somebody had to decide to sign the cheques.
Yes.
So there obviously was a decision made at that time.
Yes.
It's not a difficult inference.
It may not be a difficult inference, but it is an inferential decision that there has been a second decision that sits separately from the formal board resolution.
That would surely depend on the facts, wouldn't it? I mean, if you incur a liability to a trade creditor or employee or whatever it is, at a time when you are indebted to all sorts of other people, and when the time comes for discharging that liability by payment, you can't discharge all the liabilities to which you are subject. You then have to choose which are the ones you're going to pay, and therefore there is a real decision to be made in choosing to pay creditor A rather than creditor B. And that seems to me to be the real significance of what the judge says in the middle of just below letter C. A lot of debts were payable by the company in January, and a lot of them were not paid. So there's a choice which the directors or the company has to make when lots of debts need to be discharged about which ones it's going to pay and which ones it's not, rather than saying to everybody, well, you can have 40p in the pound of that.
I understand that, and I'm not for a moment suggesting that this is not reasonable, indeed the only reasonable inference to draw from the facts. The only point that I'm making is that there is here an inferential decision of a second decision that sits alongside and is different to the formal board decision recorded in the minutes. And a not dissimilar situation the court sees if we turn to the third of the authorities I wanted to show you, which you find in the second volume of the authorities bundle, tab 17. This is the decision of Mr. Justice David Richards, but it's still at first instance in a case called Step Construction. The facts here was that the sister, one of the directors of the company, Stealth, agreed in October 2007 to lend money to the company for a fixed term of 1 year in return for an agreement to have a security charge. When the 1 year term came up, the company was unable to pay. And at that point, the sister found out that in breach of the original agreement, she had never been given the charge that she had bargained for. So at that point, a charge was put in place. The company was wound up 7 months later. And the question was whether the granting of that belated charge pursuant to the original agreement was a preference.
The original unenforceable agreement, which
The
had no
original
legal effect.
agreement. But there had been a decision to grant a charge in October 2007, and the case made by the respondents was that that was a material decision. And as at that date, there was no reason to impute desire to prefer to the company. And what your lordships, what the court sees in this decision is that just as Mr. Justice Lloyd did in Wills, Mr. Justice David Richards thinks that the question of when the decision to grant the charge was taken called for a more subtle inquiry than simply referring back to the original October 2007 agreement. And the key passage for your purposes are paragraphs 63 and 64, bundle page 481. Picking it up at 63, his lordship says, in my judgment, the question of when the decision is made is a question of fact to be determined in the particular circumstances of each case. An existing contractual obligation is neither a necessary nor sufficient. I just underline that point. It may be very obvious, but the first sentence, this is a finding of fact we are dealing with here. You'll see then in the continuation of that paragraph, he refers to Fairway magazines, which I mentioned, Wills and Corf, which I've shown the court. And then at paragraph 64, Miss Gillis and Mr. Costa were the two directors of the company. Because Miss Gillis and Mr. Costa didn't give evidence, I don't know what discussions or decisions in fact took place in October to December 2008, except that the instructions to prepare the charge were given to Mr. Saunders, who was the solicitor in that period. That itself is some evidence that the decision was then taken to grant the charge. In circumstances where there's been a delay of over a year, and where the company was under no obligation to grant the charge, and where even then the charge was granted only because the sister raised the issue, the reasonable inference is that Miss Gillis, that's the director, whether on her own or with Mr. Costa, the other director, decided the company should proceed to grant the charge to Mrs. Ireland. So, what you have here is the trial judge reaching an inferential decision. No charge is granted when there is an agreement, albeit a non-binding agreement, in October 2007. It's granted a year later. And Mr. Justice David Richards reaches an inferential decision on the grounds that he identifies that there must have been a relevant second decision. And again, without oral evidence. Neither of the two directors are cross-examined. And they are the ones whose state of mind is, of course, in issue. So those are the relevant cases that I wanted to show the court, and I'm going to summarise the relevant propositions which we say you can derive from them. The first is that, as both the decisions in wills and stealth, most clearly wills, shows, there may be more than one relevant decision by the debtor for section 239 sub 5 purposes. The situation in those cases was the converse of the one before you, in the sense that the relevant decision in each was taken to be the later one. It is the same as the one before this court, in the sense that the relevant decision was an inferred and less formal decision. Second proposition, as the decision in Katz tells the court, an earlier decision may be relevant for section 239 purposes, even if it is conditional, in the sense that it depends on a later decision by someone else to carry it out. The directors in Katz needed the finance director and the company director to agree to repay them, and the preference claim succeeded because while the decision made by the finance director, the company's secretary, was not tainted by desire to prefer, that was the principal point urged by the respondent, it was procured by an earlier decision that was. Third point, both wills and stealth show that the relevant decision need not be some formal board resolution. They seem obvious, but the point is worth making. And in fact, the conclusion that there had been an informal decision, in addition to some more formal one, turned in both cases on inferences drawn from the judge's assessment of the commercial realities of the situation. Fourth point, where a trial judge does draw such an inference, as Mr. Justice David Richards says in stealth, that is a finding of fact and appealable as such only on the usual restrictive grounds, inference being always primarily a matter for the trial judge, and that point has a special force, whereas here facts are highly complex and the judge has seen the key decision makers cross-examined. I'll come back to a little bit of authority on that later on just to make that good.
Yes.
So much for the cases that I wanted to show to the court.
Well, now, will that be a convenient moment, Mr. Glenn?
Certainly it can be.
How are we doing for time?
I cannot imagine that we will not finish tomorrow. I would be strongly hopeful. I think I suggested to my learned friend that we divided the time up equally between us at 5 hours each. So that is what I'm working towards.
Well, we've got to finish it tomorrow.
Yes, absolutely. Yes. No, I'm sorry if I misunderstood your question. Yes, we are finishing tomorrow, and I think.
I think it was estimated for a day and a half. If I remember rightly. Was it not? Was it 2 day estimate or a day?
I understand it was 2 days.
2 days. Right. Very well. 10:30 tomorrow morning.